Now, for more information on this, you can just Google Gassman Forbes, and we're always posting the latest greatest on what's going on there. So the beginning slides is what Brandon and I were going to talk about this morning before what was posted last night. But you can use the beginning slides for conversation that the fact that the estate tax exemption is looking like it's going to go up a little bit over $12 million next year and not come down to half anytime soon. Most likely anytime soon might be that 2026 time. So what do you have? You have a lot of clients who have come to see you, who have given you their updated planning information, who have asked you to do estate tax planning, and hopefully you've done it. You've set up a spousal limited access trust for married couples. You've set up a Nevada trust that's irrevocable but may still benefit the client to get these assets out of their estate. And now it turns out that there will be no flood. You built Noah's Ark, you got the animals almost in the ark, and now the exemption isn't coming down. Well, please just spend 10 minutes on each client. Go back. Don't just close the file. Hey, Harriet and Floyd, thanks for sending me the information. You may not be as concerned about estate tax now. You should still make those moves because your assets are going to grow in value. But you can also take advantage of some charitable opportunities that are still in the tax law, and you can take advantage of ways to protect your assets from creditors. So don't just put that file away. Let's keep it out and update these clients on what we have been able to start. About 8 slides here. You can see the format. And these slides are sort of a concentrated effort to cover what you'll be seeing in the hundreds of slides that follow them. But I wanted to boil this down and just cover it for maybe 20 or 30 minutes. And then we're going to go into more depth with more slides. But the first topic would be outright gifts and the ability for a married couple to donate $600,000 in cash to an appropriate entity before the end of this year to get a $600 tax deduction, or a single person $300. And I'm encouraging my high net wealth clients to give $600 to every married couple they know and like, and encourage that married couple to make charitable donations. So that way the married couple will get a little bit of benefit from the tax deduction and hopefully a lot of psychological benefit. So even when your wealthy clients have nephews, nieces, friends, let's go ahead and give that $600 gift and then let that person make the gift and let them enjoy gifting. Because when you make a gift to charity, you feel better. There's a psychological improvement and there's a health improvement, which they can enjoy. Now, for itemized deductions, I know you all know about bunching. So every 3 to 4 years, Marcia and I will make a donation based upon what we think we're going to donate over the next 3 or 4 years. That way, we do that in the same year that we pay our property taxes so that we get a nice itemized deduction. If the client is over 70 and a half and has an IRA, then it's time to talk about a direct transfer from that IRA to the appropriate charity of their choice. And that is probably the most efficient and effective tax planning arrangement for a wealthy individual. They may have other things that they would like to donate to charity, but when you run the numbers, transferring the $100,000 a year directly from a taxable IRA to a charity is the best thing they can do. And this year, it is unlimited, because this year, the adjusted gross income limitation on donations is equal to 100% of your adjusted gross income. So you have a client or a donor who's been giving you $100,000 a year to the appropriate charitable donation. Well, if they have $10 million in their IRA, they could pull 10 million out. That gives them adjusted gross income of 10 million. And then they can transfer that $10 million to your charity and get a deduction. So there is effectively no $100,000 a year limitation. And now if the client is over 59 and a half and they can make the transfer out of their IRA to themselves, there's no excise tax because they're over 59 and a half. And then they can use this 100% of AGI. It's only for 2021. So I hope you're reaching out to everyone who is charitable with a large IRA over age 59 and a half to make sure they understand this opportunity. Now, you do have a lot of people with collectibles, also known to their spouse as garbage. So why not turn that old jewelry, that old artwork, that junky old car, why not turn that into something good for others and a tax deduction for you? And the nice thing about jewelry and artwork is that, as we know as estate planners and when we administer estates, that $10,000 painting, when it's time to sell it, may fetch $1,500. But the charitable deduction is what you would pay a retailer to purchase that asset. The charitable deduction is not actually what a willing buyer would pay a willing seller at the pawn shop. It is what a retailer in that used item would charge for it. Now, that assumes that the personal property will be actually used for the purposes of the charity. And that's why I finally realized that when I was walking through the hallways of Rollins College in the 1970s, there was always jewelry on display everywhere. And the reason was that got the donors a fair market value deduction. So you know what? If you have old jewelry and you want new jewelry, give the old jewelry away and use the tax deduction for the new jewelry. I used to have a National League Baseball umpire, and what he would do is he would get bats signed by the star players, and then he would donate the bats to boys clubs for display. And he would deduct the full fair market value of the bats, which could be $3,000 to $5,000 per bat. So he would pay $50 for a bat. Back then it was probably $5 for a bat, get it signed by the star players, and then have a significant income tax deduction. Another thing that's commonly happening now, and there are cases on it, is, okay, I buy property, I'm going to tear down that house on the property. Well, what if I donate that house to a charitable organization? I can allocate as much as possible to the house when I buy the property, and then can I deduct what I paid for that physical structure of the house, which I have decided to tear down? Well, what charity is going to use the house? We had one client who had a house on the water, and we had a barge take the house off the property and take it to the Florida Sheriff's Boys Ranch, which was on the same river, the same body of water. And then he got a nice deduction for the house. But there are charities who won't use the house other than to teach students how to dismantle a house and how to save all the different valuable materials that a house has. There's metals, there's plastics, there's systems that can be resold. And the same can go for cars. So all of those are worth setting up, even if it's just so you can donate one house. Now, there's always a lot of confusion about donating buildings. And I have a separate section on donating buildings. Yes, you can donate a building. You can donate a appreciated building or a fully depreciated building and get a fair market value deduction in exchange for that. And that would be a donation to a public charity, which could be your community foundation. It could go to an LLC owned by your community foundation, or it could be to a private operating foundation established by the clients. Because there are a lot, as you know, of very wealthy individuals who love their buildings, they love their charities, but they love their buildings more than their charities. And they don't want to sell the building and give the money to charity. In fact, they like the fact that their children manage the building. They consider the building part of their empire. But the building, they took straight line depreciation, not accelerated. It's $1 million building. They paid $1 million for it. It's all depreciated now. It's actually worth $3 million. Well, why wait till you die? Go ahead, transfer the $3 million building into your private operating foundation, operated by your children. Take a $3 million deduction against your ordinary income, and then have the rent income, which comes to the foundation tax-free. If it's rent for a normal landlord, not what percentage of profits rent, but regular rent from a normal landlord of real estate, it is not unrelated business taxable income, assuming that there's no debt against it. And then that rent income can be used to pay for scholarships or to pay for a community effort, which could be a joint venture with another charity. But some of my clients have donated buildings to their own private operating foundations, and then they interview and select recipients for scholarships. One of my clients interviews and selects employees who are working in janitorial and clerical positions in a local hospital who would like to go into nursing. So he interviews them, he gets to know them, he mentors them, and then his foundation writes checks for them to have tuition and sometimes living expenses so that they can become nurses. And that would be active enough to have a private operating foundation. A lot of clients come to me and say, I was told that unless I put $10 million into a foundation and be prepared to pay $50,000 in fees, it's not worthwhile to do my own private foundation. And I say poppycock to that. You should be able to form a private operating foundation or a private foundation for under $3,000, file a Form 1023, maybe another $3,000, get the thing up and running, see if the family likes it. If the family likes it, they're going to get a lot out of it, including their relationships with each other and the example that they are setting for their children and grandchildren. If they don't like it, they can fold it into a public charity and say that they tried it. But our philosophy is try it, you'll probably like it, it'll help your health, it will help your business senses, it will help your mental health. Go ahead and care more about others, get involved. So with buildings, you can do that. Now, if the client took a depreciation deduction for component depreciation when he acquired the building, or used accelerated depreciation, then you're not going to get the same fair market value deduction. Also, before I forget, if you set up a private non-operating foundation, which basically is a private foundation which can accept donations and then will write checks to publicly recognized charities, you can get a fair market value deduction for donating appreciated stocks. So yes, it would make great sense for Mrs. Jones, who has $1 million worth of stock that cost her $10,000, to transfer that to your community foundation to get $1 million tax deduction. But she wants control. So she could use a private foundation, and as long as the appreciated asset is publicly traded stock, that will work fine. So my next outright gift is part ownership of a business. You could read 100 pages of information about the excess business holding rules and the self-dealing rules and conclude that there is no way to keep control of a business partly owned and gifted to a charity. And that is not correct. We are going to show you how you can gift part ownership of a business entity to a charity, whether it's a public foundation or a private charity, in a few minutes. Another idea for your clients is have a party for charity. Now, I don't know about you, but when we meet with married couples, they don't always agree on things. One may want to donate a lot of money. One may rather prefer not to donate money. One couple I have, one spouse hardly ever wants to donate, but she loves to save taxes. So the first few years of the relationship, they were not making donations because we would say, well, you know, you've got a passion for the YMCA and we see this YMCA program. Do you want to put 10,000 over there? She would say no. Her husband would say yes. But we learned that in December, when we say to her, would you like to save some tax dollars? Yes. How would you do that? Well, you would give $100,000 in appreciated stocks to your community foundation or your donor advised fund. She says, yes. Okay, now it's March. And the husband says, hey, I'd like to help this YMCA program. She goes, where's the money going to come from? It's going to come from that donor advised fund account I set up. She says, no problem. It's not coming out of her pocket. So a lot of this is the psychology. But going back to the psychology, that reluctant spouse may be interested in social events. So have that spouse throw a party for charity. First of all, you'll probably spend more on the party than the charity will raise, especially when you consider renovating the home. You know how that works. We're going to have a party. We need to remarcite the pool. So nevertheless, though, this will involve the family in the charity. And why not have a tax-deductible party? If you write a check to the charity may pay for the party, and it needs to be a purely charitable party. Make sure that you do not have fun at this party. Page 16. When I first started practicing, I had, believe it or not, a fee dispute. And I had done about $15,000 worth of estate planning for a family, and they did not want to pay me, and they went to an older, very good lawyer in St. Petersburg, Florida, named Joel Bronstein. And Joel called me, and he said, here's the way to resolve the dispute. Do you give to charity? Well, yes, I do. What's your favorite charity? Well, All Children's Hospital. Okay, well, how about if I can get this client to give a check for $5,000 to All Children's Hospital and the other 10 to you? And that is exactly what we did. So Marcia and I have an annual goal for a certain amount that we want to give to our 3 favorite charities. So when I have an issue on fees or a client is just belly aching about the fees, I'm going to say, would you just make a donation to one of these 3 charities? And the client says, sure. And then I check off in my mind, there's towards my annual goal for the charity. Another thing that we do is I don't give free consultations. It is a very rare event when I give a free consultation. And the reason for that is, number one, I can't stand rejection. And number two, I find that the clients who want a free consultation are not nearly as good as the clients who don't care whether they get a free consultation. But every once in a while, my intake person will come to me and say, well, you know, this would be a very, very good client for us, but she's a little bit hung up on paying for the first consultation. But she did say that she would go ahead and make a donation to one of your favorite charities if we can make this happen. So that's just another way to try to make things happen. Again, moving a historical property to a museum or an orphanage, or changing your collection. We have individuals with great, huge weapons collections, great, huge car collections. Well, maybe go ahead and convert that to a museum or start your own museum. Now, we do have clients who want to give more than the 50 or 60% adjusted gross income in some years, and it will go back to 50 to 60% of adjusted gross income for 2022. These clients can make interest-free loans to charities and then possibly forgive the loans later if they decide to. They can also provide charities with free rental space without charging rent. And they can pay from their business for advertising and sponsoring business activities. They can also encourage their family members to make deductions, and they can form irrevocable complex trusts, which can get an income tax deduction for making payments to charity. And we're going to talk more about that. But when you have the charitable donation incentive and various family members, maybe if grandma wants to donate $20,000 to the church, she should get her son to do it. He's in a much higher bracket. You talk to him, you talk to grandma, and you see if there's a way to make that happen. And maybe he'll donate the tax savings to the church and make something happen. So, page 17, and that is legacies on death. And a lot of extra tax money gets paid because donations are not deductible. So if I die and my trust says, give the Birmingham Community Foundation $100,000, I'm not getting an income tax deduction because I didn't do that while I was alive. And my children are not getting an income tax deduction because it's coming from my estate. But on the other hand, if my trust says, establish the trusts for my children, and from those trusts from my children, pay the first $100,000 of income to the Birmingham Community Foundation. Well, now the $100,000 of income is carried out to the foundation, which pays no tax on it, and my children have no income tax on the first $100,000 that they would pull out of that trust. Secondly, though, if I have an IRA that's going to be subject to income tax and it's going to be subject to the stretch IRA rules and have to come out within 11 years of my death if it doesn't go to my spouse, it is so much better to put the IRA beneficiary designation into place as $100,000 to the charity, the rest to my beneficiaries. That's going to save my beneficiaries income tax on $100,000. Now, I have one of my favorite tax professors there, Professor Dennis Calfee. He still calls and tells me he's going to downgrade my partnership tax exam grade if I don't hire his law clerks. You know, if you had somebody who really made the difference for you getting through college, law school, an LLM program, or whatever it is, send them an email and tell them how much you appreciate what they've done. You know, and when you mentor other people, don't forget how incredibly important that is. Okay, so we've talked about giving IRD, income in respect of a decedent. Life insurance, if you have an old life insurance policy and you don't want to pay the premiums anymore, you could donate the policy to the charity, and the charity can pay the premiums, and you could donate money to the charity to pay the premiums. It's just an idea. It doesn't always happen, but it can happen. Now, the estate tax is a purely voluntary tax. You only pay the estate tax if you are not willing to support charity. When Warren Buffett dies, if he is leaving his entire estate to the Bill and Melinda Gates Foundation, which is pretty much what he's announced, he will pay no estate tax. But he could pass his estate approximately 40 to 50% to his descendants over a 15 to 20 year period, and the rest to charity, and still pay no federal estate tax. That is by use of a charitable lead annuity trust. And we're going to talk more about the Charitable Lead Annuity Trust, but just don't forget to tell your clients, by the way, if you'd rather take your 50 million that you're leaving and not have it be subject to 20 million of estate tax, you could leave the 50 million to a special trust that would pay 7.3% of its day one value to your favorite charity for 15 years. And then whatever is left for your descendants would pass estate tax free after the 15th year. And that gives them 15 years to grow up and be mature. So please at least offer the Charitable Lead Annuity Trust to wealthy clients, because many wealthy people come to us for advice and they've never even heard of it, and they're charitable and they're glad to know about it. And here's the other example. I leave half of my estate to my daughter who needs it and is not charitable. I leave the other half of my estate to a trust for my son who is financially successful and charitable. And within 9 months of my death, my son's trustee can elect to keep that devise in whole or in part and pay the estate tax, or to disclaim some portion of it, in which event it will go to a community foundation or other public or private charitable organization to completely avoid estate tax. If your client doesn't want to make the decision, they don't have to make the decision. Their children can make the decision in their honor. Now, what other clients do, if there's no IRA and there's no income tax going to be paid by the client, but they're leaving assets to a high bracket child, instead of saying, I leave $1 million to the ABC Museum, where there will be no tax benefit, put in the will, I leave $1 million to my son, and strongly encourage my son to donate the $1 million over time to the ABC Museum. And if he doesn't, I'm going to haunt him. So now the same $1 million goes to the museum, but the son gets $1 million of income tax deductions. Now, this assumes that the parent is not subject to federal estate tax, but we definitely want to consider that. Now, charitable remainder trusts can be formed on death, and we will talk about that a little later. Okay, now, keeping the giving away the tree, but keeping the fruit of the tree. I was recently completing an estate tax plan for a charitable client, and a financial planner who I have a lot of respect for came in at the last minute and came up with an idea that, quite candidly, I hadn't thought of. This client has approximately $10 million worth of rental property, and at a 6% rate of return, because there's no debt, receives about $600,000 worth of income. And he happens to like that income. So when I said, would you like to put the building into a foundation? He said, no, because I want the income. Well, the financial planner said, how long do you want the income? And the client is 60, and he said, I want it for 12 years. So the financial planner said, okay, let's put that rental real estate into a charitable remainder trust, which will pay you 7% of the day one contribution value for 12 years. And then after 12 years, it will go to your private operating foundation. And not only will you get that $700,000 or $600,000 of rent a year, but you will get a very large income tax deduction, also known as money from the government, just for setting it up now. And your new spouse, who may not be as charitable as you, will not have as much of an opportunity to change this structure if you die or become incapacitated during these 12 years. So the client said, this is a no-brainer. it's all going to charity by the time I die anyway. Why wouldn't I get the income tax deduction now? The other thing that you can do is give a remainder interest in a personal residence. It doesn't have to be your primary residence, but it does have to be a personal residence that you use personally. You simply sign a remainder interest deed, which says, I retain the right to full use and control and all rent income and the obligation to maintain this house and the adjoining property during my lifetime. But on my death, it's going to go to charity. And thank you, Uncle Sam, for a check that you're writing today for the present value of that remainder interest. And then you can do that with your primary residence, you can do it with your vacation residence, and you can do it with a farm. Later on, you can donate the life estate to the charity and get an additional deduction based upon the value of that life estate at a later time. So that is page 18. Now, page 19. And this is where it can get even more exciting. And that is when a client hopes to have a liquidity event. And by liquidity event, I don't mean drinking a lot of beers. I mean selling their business or selling a real estate where they're going to have a large capital gain and a large income tax obligation. And especially if this pushes them past $10 million and this new law passes, it's going to be even more pronounced. So the first step is please tell the client, if you will donate part of this to charity before the sale, you will save a lot more in tax dollars. So I have an example there. If you're going to have $1 million sale and you donate 20% to charity, then you're going to have a $200,000 tax deduction and no income tax on the 20% portion of the sale. But on the other hand, if you first sell it, then you're going to have to pay income tax on the 20% portion. And the difference is significant. In the example there, the difference is $142,800 on a $1 million sale. So it's a little bit more complicated to donate part of the building or part of the business company to the charity before the sale, but it saves a lot of tax dollars. And when would you do it? You would do it immediately before the sale so that the client knows the sale is likely to happen and can document that the value is very close in time to what the willing buyer paid for it. But you have to do it before there is a binding obligation to sell. So the client comes to me with a letter of intent and says, this thing's about to happen. Will you review the documents? What should I do from a tax standpoint? My first advice is don't sign the contract for sale until after we have made a transfer of part ownership to the charitable organization. And, you know, in a lot of transactions nowadays, you just sign everything at closing. You explain to the buyer, hey, we're doing a charitable thing here. We don't want to have any legal obligation to sell until the closing. Sometimes the buyer will go with that. Sometimes they won't. But the main thing is the letter of intent should be non-binding. The letter of intent is the stage you want to be in when you donate part of this to charity. And I'll be giving you more information on that later. What about if the client doesn't want to give a lot to charity, but also really doesn't want to pay income tax on the sale? Well, using a flip NIMCRUT, which we'll be reviewing later, you can put that asset into the flip NIMCRUT, also known as a charitable remainder unit trust, just before the sale, before there's a binding obligation to sell, get a tax deduction for approximately 10% of the value of the asset you put into the NIMCRUT. Then the NIMCRUT sells the asset. And even if the NIMCRUT has depreciation recapture because it took ordinary accelerated depreciation or component depreciation, even though there's ordinary income resulting from the sale, maybe because it's short-term capital gain or Bitcoin, you can still defer the income tax safely for up to 14 or 15 years and take a very large deferred payment anywhere between years 2 and 15, based upon how much is built out, and then convert the NIMCRUT to a regular charitable remainder unit trust by flipping a switch and then receiving 4 or 5 remaining payments, to where when you run the numbers, the charity will receive less than 10% of the total value. But the client will get a charitable deduction for 10% at the time of the contribution, and income tax deferral for 14 or 15 years. Now, if the client lives in a high income tax state and will not live in that state 14 or 15 years later, or if the client expects to be in a lower tax bracket 14 or 15 years later, then this makes a tremendous amount of sense. And this is one where even if the client is not charitable, quite candidly, the numbers can justify getting this done. Keeping in mind that the non-charitable client still wants to help their family. So the idea that I could get a tax deduction for putting assets into a foundation that could be managed by my grandchildren, who could be paid compensation at a much lower income tax bracket than I pay to put it in, can be appealing even to people who are not very charitable. And by the way, on the question of how charitable is your client, I will say, based on experience, that this will change over the years. That a client who 10 years ago told you, I don't want to give anything to charity, it's all for my family, leave it to my family to take care of charity. Well, 10 years later, there may be a children's hospital that saved their grandchild's life. There may be a study on diabetes that saved their life. There may be a divorce and a lack of people that they want to give to. There may be estrangement with children. So don't hesitate to always ask the charitable question. You know, I keep track of how much in value has gone to charity each year from our clients, feeling pretty proud that to some extent I've been able to help make that happen by showing them the best path, by giving them the polite nudge, by giving them the applause that they deserve and the assurances that they need that this is being done in the right way for all of the right reasons. So page 20, again, what we call the flip NIMCRUT. I don't think you need to know how my car works. You just need to know how to get in my car and drive it around. So you should not feel that you cannot talk about these techniques as if for some reason you would have to completely explain it. I cannot explain all of these techniques, but I've made sure to learn enough so that I can see if they would fit a client, talk to the client about it, and then bring in an expert who does this every day, 50 hours a week. In our firm, we might spend 5 hours a week on average in charitable areas. That's not enough. So I have to go get help. And that's where your George is there. People are around. They are interested in helping you. But please dig deep to the extent that you can feel comfortable with what I'm talking about, at least from a conceptual standpoint. Now, another reason that the estate tax is a voluntary tax is the administrative note exception. And the administrative note exception to the self-dealing rules basically says, instead of leaving the business or the assets to charity, your children owe a note for the business or assets to the charity, and then there's no estate tax. So, for example, I would die and leave a $100 million business to my children, and they have to pay $40 million in estate tax over a 14-year period. On the other hand, I could leave my $100 million business into my estate, and my estate documents can provide that the business will go to a foundation or a charity, but the children could instead take the business and owe a note to the charity. So instead of the children receiving the business and owing Uncle Sam $40 million, the children receive the business and they owe the charity a 25-year low interest note for $100 million. And what is the value of a 25-year low interest note? It's not the face amount owed. There's going to be a substantial discount. And if the note is owed to a public charity, then there could be a cash out. And a public charity waiting to receive a $100 million note in 25 years with interest at a very low rate may be very happy to get a check for $50 million. That way you have $100 million of value in the foundation. I'm sorry, that way you have a $50 million value in the foundation and $100 million value has gone to the children. Instead of paying Uncle Sam $40 million, they paid their own foundation $50 million. So it's a mundane tax provision, and there's been very little written on it. But that is the administrative note exception. And that is one of the reasons that the estate tax is a voluntary tax. Now on page 22, I talked about the use of disclaimers already. So there it is for you. Page 23, I've spoken about leaving a device to a high income child who can donate it to charity. Sometimes you have other items of ordinary income, such as the variable annuities. I am not a fan of most variable annuity situations, but you do have clients who have $100,000 that they put into a variable annuity and now it's worth $200,000 and they have $100,000 of ordinary income that's going to come out of that annuity. Well, make the annuity payable $100,000 to the foundation and the remaining amount to the family, and that income will be carried out to the charity. I'm going to double check that and make sure you don't have to leave the whole thing to charity. I'm going to fill in this middle pane with that the next time you ever see this presentation, and hopefully it won't be a pain. But those are the on-death ideas. Now, using family foundations, I want to point out before I forget, I've talked about setting up a simple family foundation. We normally set these up as trusts. It's a fairly simple trust agreement. And what I like about trusts versus corporations is trusts don't go on the public records. I don't have to tell the state of Florida that my client set up the John and Mary Morgan Operating Foundation. I tell the IRS, but I don't have to tell the state of Florida. I don't have to pay an annual filing fee. I don't have to have 3 unrelated directors or whatever state law requires. With a charitable trust, usually there's no requirement. The client can simply be the sole fiduciary. I don't know what your Alabama charitable organization rules are, but this may work well for you. Now, we have also established incomplete gift family foundations. And what is that? Well, a client came to me and said, I'm about to remarry and I like everything about my new spouse except for the fact that he's not very charitable. And I don't want to have any misunderstanding whatsoever that during my life or after my death, the $1 million that I have promised to my alma mater will go to the alma mater. So what do I need to do to make sure that happens? And by the way, if I get sick and run out of assets, I want the $1 million back. Well, we established what I called an incomplete gift family foundation. She signed a trust agreement. It gives her the ability under certain circumstances to revoke it. But it is called by her name as the Family Charitable Foundation. It authorizes payments to the alma mater or to her as reasonably needed for her health, education, and maintenance. And the prenuptial agreement provided that that is not only an untouchable asset, but psychologically, the whole family understands that that's where that asset is going on the client's death. The other time that I've used the Incomplete Gift Family Foundation is when clients say, you know, I'd like to do a foundation, but I don't want to pay $6,000 to $8,000 to set it up. And I don't even really know if my kids and my grandchildren are going to be excited by it. So I say, okay, great, let's set up the foundation, but it won't be strictly charitable. We'll tell your family it's charitable, set it up, put $100,000 in it, have a family meeting, decide what the children want to do. And if they distribute money to charity or assets to charity, you'll get the deduction at the time of the distributions. And if they're enthusiastic about it, then we'll go ahead and set it up as a formal charity. If they aren't, then you'll still have the organization. And some clients, quite candidly, find value in being able to donate $100,000 to a public charity to name a hallway, and the hallway says the John and Mary Simpson Charitable Foundation. They like that better than just it saying John and Mary Simpson. It makes them sound bigger and more philanthropic. So go with the flow here and offer the Incomplete Gift Family Foundation to satisfy the ego and the recognition. Or the cocktail party conversation, and maybe not for much else. Do understand that there is a 501c4 organization called the Social Welfare Organization, which can be established to help political causes, lobbying, and political action committees, and to do good in a community, or to support politically biased types of causes. And a 501c4 organization can receive a gift without the donor incurring gift tax and is not subject to income tax. So if grandpa has an oil and gas interest that pays him $10,000 a year, and he wants to donate $10,000 a year to political causes, then he can go ahead and donate the oil and gas interest to the 501c4 organization that you set up for him. And then that 501c4 will receive the $10,000 a year, donate it as he advises, and he will not be paying income tax on the $10,000. In addition, the 501c4 may own the 1% voting stock of grandpa's company. And then grandpa may be able to donate the non-voting stock of his company to a private foundation or a private operating foundation without violating the self-dealing rules. Now, that's something you want to take a close look at, but it is not an uncommon or unheard of strategy. 26 is a summary of the tax law as it stands today in 2021, where you have the 300 to 600 per couple outright distributions. Up to 20% of adjusted gross income can be written off for appreciated securities transferred to a private foundation. If your client will start a private operating foundation, then up to 30% of appreciated assets can be given, and it doesn't have to be just marketable securities. It can be real estate. It can be private securities, so that's a private operating foundation. And then for 2019 and 2022, we'll go back to the 60% of adjusted gross income limitation, where they would give 30% in appreciated assets and then would need to give cash to get a donation above that. We see here that C corporations can deduct up to 25% of taxable income to charity this year and last year. It goes back down to 10% in the following year. Okay, page 27. I want to talk about the charitable organizations because I think most advisors believe that even a wealthy client cannot really set up and get the advantage of a public charity. So the main difference between a private operating foundation and a public charity is that a private operating foundation has to distribute 4.25% of its value or spend at least 4.25% of the value or use at least 4.25% of the value for the charitable purposes. Whereas a public charity does not have to make any minimum distributions. Secondly, a private foundation is subject to the related party rules, the self-dealing rules. A public charity is not. So our clients who have had very large charitable donations have preferred to have a public charity. Well, the way that an organization becomes a public charity is to receive at least 33% of its support from under 2% donors or 66% of its support from under 2% donors and fundraising. But that's usually not easy to do. Although I have had one client who spent more money on fundraising than the funds that he raised, but he was still able to qualify. The bigger exception is to operate a school, a hospital, or a church. Now, a school, by definition, is a physical place that could be rented or owned by the 501c3 organization where you have one or more students, a faculty, one or more teachers, and actual subjects. So it can't just be a general enrichment program or a community center. It has to say, at 8:00 p.m. on Wednesday, we are teaching karate. And there is one private letter ruling where a karate school qualified as a public charity. Now, I said a public charity does not have to make any minimum distribution or any minimum expenditure in order to qualify. And that's an advantage. In many states, you can establish a charter school, and the charter school will be a 501c3 organization, and the state government will pay you to operate the school. In Florida, charter schools receive approximately $6,000 per year per patient, per student. And some charter schools actually operate based upon that. So another example is I had a medical physician client who set up a medical research organization. The reason he did it was because he had a profitable research operation going on in his medical practice, but he found that if he could be a public charity, that he would get many, many more grants and be able to grow the organization, which was his goal. His goal was not personal income. His goal was to make a difference in the world with research on medical conditions. So we set him up as a 501c3 medical research organization, got public charity status. So now he's able to get much better grants. And this organization can own, because it's a public charity, it can own interests in other companies that he is involved with And it can even buy and sell assets with him because the disqualified person rules don't apply to public charities. So this is why the St. Petersburg Times is owned by the Poynter Institute. Mr. Poynter died in the 1940s, I believe, or 50s, and left the ownership of the for-profit newspaper to the school. And that is the reason that 2 or 3 national newspapers in the United States are owned by charitable organizations. So I have a lot of information on these charts about all these rules, and I'll tell you something, no matter what the chart says, double check it before you rely, because as Jay Atkinson says, for every rule, there's an exception, and then for every exception, there's 2 other exceptions. So you have to be careful, but you can get a feel for what you can do with each particular entity. So a little bit of show and tell here. On page 31, a client says, well, you know, I like the charitable giving, but I am more into the estate tax avoidance. Can I do them both? And the answer is, of course you can. So let's say you have a company worth $3 million and you want to avoid estate tax and income tax. So you set up a dynasty trust for your children, maybe for your spouse, it's a slat. You give it a seed capital gift of $200,000. It's out of your estate for estate tax purposes. It's disregarded for income tax purposes. You sell it, the 99% non-voting member interest in the company, in exchange for a $2 million note. And when the company sells in a few years for $5 million, you've got that $3 million difference out of your estate for estate tax purposes. Well, once the dynasty trust owns 99% of the company, it could transfer the 99% non-voting interest in this C corporation to a flip NIMCRUT. You would have the 1% voting held by an unrelated party. Now, when you sell the C corporation stock to the NIMCRUT, now when the NIMCRUT sells the C corporation stock for $5 million, you're not going to pay any tax on what could be $5 million in gains for normally 14 to 15 years. So you can use both techniques. In fact, an S corporation could form a NIMCRUT. So if you have an S corporation that will sell its assets, you could have the S corporation contribute the assets to a NIMCRUT and have the NIMCRUT sell the assets, as long as you don't run afoul of the unrelated business income rules, which have to be carefully considered. Page 33, and this is a transaction that we did last year. So the client owned a S corporation. The S corporation owned a disregarded entity, and the disregarded entity owned a C corporation that was looking to have a liquidity event, a very large liquidity event. So what we did was we had the C corporation here or actually the disregarded entity here made a pledge to a charitable foundation and said, within the next 2 years, we are going to donate 10% of the ownership of this company to you, Mr. Foundation. And until then, if there are any distributions, we're going to give you 20% of the distributions. Okay, that reduced the value of this LLC by about 20%, because nobody is going to buy this C Corp subject to that obligation without a substantial discount. Then the second thing we did was we sold the 99% non-voting member interests in this company, this S corporation, to a spousal limited access trust in exchange for a low interest note, and a descendants trust in exchange for a low interest note. Now, the notes were for significantly less than the remaining 90% value of the C corporation. And we did that to avoid federal estate tax. So then the sale occurred. Then after we did that, after we did the installment sale, the next step, before there was a binding contract to sell this company to third parties, the disregarded entity went ahead and made the 10% donation of stock to the private operating foundation. They got a nice tax deduction. And then after that, shortly after that, the C corporation was sold. The 10% of the sales proceeds went to the foundation without being subject to any income tax. And the 90% went to the S corporation, which is going to be outside of the estate of the clients for estate tax purposes. The clients in this case did not form a charitable remainder unit trust to defer the income tax. They could have, but they decided to go ahead and pay the income tax. Believe it or not, this was complicated enough for their tastes. 34. This is just a situation where you put the voting stock of a C corporation into a special kind of trust, which is specifically authorized under Code Section 4946A1G. So Section 4946A1G says that an individual serve as trustee of a trust for a complex irrevocable trust that has less than 35% of its benefits and beneficial holdings be for the possible benefit of that trustee and his family or her family, results in that trust not being a disqualified person. So now the client can own non-voting stock and donate non-voting stock to the private operating foundation. Now, to get a full deduction, the private operating foundation can be given a put right, where it has the right on perhaps 1 year's notice to get bought out of the for-profit entity for 40% of the value of the for-profit entity, so that the income tax deduction can be without a discount. Now, the alternative would be, instead of using the Section 4946A1G trust, you would use a 501c4 organization, or at least I've seen Attorney Berry's recent Notre Dame Tax Institute materials throw that out as an alternative that, quite candidly, I had not heard or seen before. Okay, the installment sale to the defective grantor trust is more popular than ever now. It's not going away anytime soon, according to at least Senator Sinema, who will not vote for increasing estate taxes or doing away with estate and gift tax loopholes as last reported. So when I make an installment sale, and I'm concerned that the IRS may say that I didn't charge enough, that the promissory note that I get back from the trust in exchange for selling 99% of my business is not enough, and that I've made a bargain gift, I am going to advise the client to use what we call a McCord-Petter arrangement, where under the Wandry tax court decision, Wandry sold ownership for a note, but the assignment provision said, I hereby assign a portion of the company equal to the value of the note. And the tax court said that that was okay, but it was a memorandum decision. Problem, or the issue with the Wandry clause, is whether it's against public policy. And we don't have a full tax court decision or any appellate decision saying that the Wandry clause is not against public policy. But in the McCord and Petter cases, the overflow went to charity. So the overflow provision said, I hereby sell these interests for this note. But if it turns out that the interest is worth more than the note, the excess goes to the charity. And I believe in one case it was a symphony. So the said this cannot be against public policy because it's going to charity. Giving to charity is not against public policy. So it's more complicated to draft these. And if you follow the pattern that McCord and Petter followed, they actually gave part ownership to charity at the time of the sale, a very, very small part. And then they gave money to charity. The charity used the money to buy lawyers and valuations and reevaluate everything and act like a full arm's length charity. And the appellate courts said that this was just fine. So be careful of all the different rules that apply when you give part ownership of a company to charity and when you don't know what that company is. But these are certainly feasible. Now, I want to just show you two more zero estate tax structures, just so you have these so that you can explain them to clients. This family has a $20 million irrevocable life insurance trust, so the children are probably not going to miss a meal. And then the parents have also set up a descendants trust, which has more assets where they've used most of their estate tax exemption. Then on death or during the lifetime of the client, a 15-year zeroed out CLAT. If the client's alive, they're going to get an income tax deduction for the value of what goes into the CLAT. The CLAT is going to own a limited partnership interest in a family limited partnership. Using discounts, you're going to expect that the CLAT will have a fairly large value after 15 years that will go to the children. The CLAT is making the 15-year payments at about 7.3% a year of the year one value to the private operating foundation. And the clients donated 99% non-voting member interest to the private operating foundation and put a 1% voting interest into a 4946A trust, so there'll be no estate tax here. Now, inside this descendants trust was a lot of appreciated real estate. So when we made the large donation to the CLAT, generating a large income tax deduction because it was a grantor CLAT, we actually had the descendants trust trigger income tax on the real estate. So let's say that there was a $10 million piece of real estate that was going to be developed. It was development real estate, $10 million worth with a zero basis. Put that $10 million worth of real estate under the descendants trust into an S corporation, and then we liquidated the S corporation. That triggered $10 million worth of income tax and gave that property a $10 million basis. Then over here, we put enough assets into the CLAT to zero out the income tax, and now the descendants trust can develop that property, which has a $10 million basis instead of a zero basis, to have much less dealer income. Now, the alternative to this on page 38 is the administrative note. So the children come and say, wait a minute, don't give it all away. We want more than the descendants trust and the irrevocable trust. Give us the real estate business and we'll pay the private operating foundation by a low interest 25-year note. And then later on, the private operating foundation will convert to a public charity by operating a school, and we'll renegotiate that note, and we'll give the private operating foundation either interest, which will be tax deductible to us, or prepayments on the note, so the children end up with more than that. So those are just more examples of what can be done. Now, on page 39, I have the different types of organizations and how deductibility works. And of course, you're going to want to know about these organizations. If you set up a charitable lead annuity trust during the lifetime of the grantor as what we call a grantor clat, then this is considered to be a donation directly to charity by the grantor of the amount going into the clat. So not only do you have the estate and gift tax avoidance, but you are going to have an income tax deduction. Now, during the lifetime of the grantor clat, the grantor will pay income tax on the income of the clat, but got a very large deduction in the first year. And if the clat invests in closely held stocks, there's not going to be very much income. To become familiar with the unrelated business taxable income rules and confer with lawyers or accountants who are very well versed in these rules. Please know that when you give a partnership interest to one of these entities, the unrelated business taxable income is based upon the activities of the partnership. So it could be partly non-taxable because the partnership is renting real estate, which is not unrelated business taxable income, but it could be partly taxable. For example, if the partnership is operating an active business that has nothing to do with the charitable purposes. So that's the way. So slide 40 shows you unrelated business income directly held by the entity, and too much unrelated business income reported to the charitable entity can cause loss of 501c3 status. Here on page 41, we are showing you what it looks like if there is a partnership entity. And partnership entities do not do well with charitable remainder unit trusts because of 100% excise tax on unrelated business taxable income paid by a charitable remainder unit trust. S corporations have all of the K1 income considered to be unrelated business taxable income to the charity that owns an S corporation interest. So you typically would not be setting up entities as S corporations if they are going to find their way into a charitable organization, and they will completely lose the S election in a CRUT or in a charitable lead annuity trust. So the C corporation is often the answer. Right now, as you know, it's in the 21% tax bracket. Eventually, C corporations will probably be in higher tax brackets. The C corporation pays its income tax, but then when the C corporation makes a distribution to the charitable organization, that is not subject to tax because unrelated business taxable income does not include passive dividends, does not include passive rent, does not include passive royalties. And if the C corporation is a foreign corporation and you have competent foreign and domestic counsel, then you may find that the C corporation is not subject to U.S. income tax, and the contemplated dividend tax that applies when a C corporation makes a dividend to its shareholders doesn't apply in the charitable area. So that gives you some background. The only other thing I want to show you before Chris Denicolo, who has joined us thankfully here, is when you have a client who wants to, I'm just looking for the slide. When you have a client who wants to leave everything to charity, consider leaving some of it instead to an irrevocable trust, which can help people and charities so that you can use up that $11,700,000 exemption and own S corporation stock, pay benefits to specific individuals, which a charity typically can't do, not be subject to the self-dealing rules, etc. So you can have what I call a credit shelter trust for charitable purposes that you can consider, and you can also leverage the assets. So you could have the charitable trust worth a net of $11.7 million, actually receive $22 million worth of assets and owe a note to an LLC, which becomes owned by a clad in this example. So here there would be no estate tax with a lot of S corporation stock held in a complex trust that would be used for charitable purposes. Under Section 642C, what the trust pays to charity does not get subject to income tax. It can keep the S election, and then you can zero out the estate tax by leaving everything to either a CLAT or to just a charity. The charity can own the 99% non-voting interest, and this is approved by some private letter rulings. So, Christopher Denicolo, thank you for joining us. Chris,
my pleasure to be here.
Chris is a primary author on a book that we've provided everybody, which is the Planning with IRA and Pension Benefits, which is one of the most complicated and uninteresting area of the tax law. But we undertook to take everything in Natalie Choate's book and to put it into easier to understand form. And we are big fans of Natalie Choate and thank her for everything she's done. But our book someday perhaps could be a companion book to her book. And in our book, which you now have a copy of, we have a number of slides where we have tried to simplify the use of IRAs being payable to charity or for charity purposes. So for the next 15 minutes, it'll seem a lot longer. Probably you feel like you've been here 6 hours. Chris is going to go ahead and, Chris, do you want me to turn the pages for you?
Yeah, that'll be fine, Alan. So
Okay.
One of the great things about IRAs and retirement plans, of course, is the tax deferral. But with that benefit comes the cost of the income tax that applies when these assets are ultimately distributed. So in its very simple form, you have a traditional IRA, you fund it with monies that are deductible up front. It grows on a tax deferred basis. And when monies come out, they are subject to income tax at the then income tax rate. And for that reason, IRAs and retirement plans are excellent assets to leave to charity because charitable beneficiaries do not pay income tax on these assets. So one of the most straightforward and easy ways to effectuate charitable devices or charitable testamentary intentions is to have an IRA or retirement plan payable to the charity. And that is about as straightforward as you can get. However, it's not always appropriate given situations because many of our clients have other beneficiaries that they want to have benefit. They have other beneficiaries in amounts that need to be allocated. So what we're going to talk about over the next few minutes is how to get these assets to charity in the most optimal tax way. And one of the more common ways to do it is to have the IRA payable via beneficiary designation to a trust, and the trust itself determines how much goes to charity and how much goes to non-charitable beneficiaries. Now, many of you may be familiar with the rules regarding IRA and retirement plan payouts, and they say that you cannot have non-individual beneficiaries of a trust that qualifies as a see-through trust. A see-through trust is a fancy way to say the IRS will look through the trust to the beneficiaries to determine whether the IRA has individual beneficiaries that allows for the IRA distributions to come out over 10 years, or in some instances over life expectancy of beneficiaries. There is a very special deadline called the designation date, and it's easy. It's September 30 of the year after somebody dies. So when the participant dies, September 30 of the next year is the deadline by which all non-individual beneficiaries must be paid out. So when you have a trust that pays to charity and non-charitable beneficiaries, it is important to make sure that the charitable beneficiaries get their distributions before that September 30 day. Now, the devise to charity can be done in terms of a pecuniary amount. And Alan, if we go to the next slide, we can start, two slides from now, we can start talking about how to get to charity. You can have the trust provide for a flat dollar amount to go to charity, a percentage of assets to go to charity, or you can have a child or a beneficiary execute a disclaimer within the 9-month period following the participant's death to cause assets to go to charity. And this might work where you name the charity as a secondary beneficiary and name the child as the primary beneficiary. In fact, you can even name the private foundation as the secondary beneficiary, and the child can execute a disclaimer or decide how much of the assets they want to disclaim within that 9-month period. It's important, of course, that if you do have a qualified disclaimer mechanism at play, the child or whoever disclaims cannot be part of the decision-making or should not be part of the decision-making of the foundation, because that might render the disclaimer as invalid, which is an important distinction here. So Alan, on the next slide, we have a similar approach, which involves the use of a charitable remainder trust. Now, having a charitable remainder trust as a beneficiary of an IRA has become popular since the Secure Act was passed starting in 2020. And the reason for that, as we'll discuss in just a few minutes in more detail, is because a charitable remainder trust can essentially create an artificial stretch of IRA benefits to a beneficiary. So similar concept to what I just explained. Have the child as a first choice beneficiary, have a charitable remainder trust as the backup beneficiary under the beneficiary designation. If the child executes a disclaimer within 9 months following the parent's death, then the charitable remainder trust will receive the IRA, and it does not pay tax. So even though the IRA must be distributed within 5 years, meaning that the assets must come out of the IRA within 5 years, they will stay under the charitable remainder trust and be payable over the course of the beneficiary of the remainder trust's life, or over a certain time period, to create that artificial stretch. So Alan, we're going to move forward to slide number 149. So this is just a good summary we have here on how to pay IRA benefits to charity. And as I mentioned, leaving assets to a charitable remainder trust could provide for a stretch over the life expectancy or over a number of years in a manner that now doesn't exist in a lot of situations under the Secure Act. I also wanted to mention, of course, this idea of having a qualified charitable donation or qualified charitable distribution. And what that does is it allows a participant to take up to $100,000 of their required minimum distributions during lifetime and instead have them paid directly to a public charity without the taxpayer paying any tax on that distribution. So this is helpful if you have a taxpayer who might not otherwise benefit from receiving the distribution and subsequently contributing the distribution to charity due to AGI limitations or for other reasons. Instead, you can have the monies directly go from the IRA to the charity, and this can be a great tool for those wealthy clients who have large IRAs and have required minimum distribution obligations and want to make charitable distributions. It is a very helpful way to effectuate the transfer, and we recommend that a lot of wealthy clients do so, with the caveat, of course, that it must be a public charity. It cannot be a private foundation that receives this qualified distribution. So Alan, on the next slide, just going to review the use of a donor advised fund here. Now, we talked earlier about having retirement plans paid directly to charity, and that is a very effective and straightforward way to both effectuate charitable intentions and also receive an income tax deduction. You can substitute for the charity a donor advised fund or a community foundation, similar to what Alan and George were discussing earlier, and that can help with getting the income tax deduction, or I guess the non-recognition of income tax that would come from pulling assets out of a retirement plan. So when you have a donor advised fund, you can have members of the donor's family in charge or have a say as to which charities benefit here. And you also can use timing. You can delay transfers to ultimate charitable beneficiaries over the course of a number of years, which could give a client more comfort and might be an entryway into getting a client to implement charitable distributions. Because some clients, as Alan said, may not be charitable up front, and they may wade into the pool of charitable giving, and the donor advised fund is an excellent step to effectuate that and allow them to do so. So Alan, on the next slide, I want to go over just a big no-no, and that's leaving assets in an IRA to an estate, which in turn pays to a charity or non-charitable beneficiary. And the reason for this is because the estate is a non-individual. The IRA assets have to come out within 5 years of the participant's death generally. Now, the estate can contribute the assets or distribute the assets to charity and get a charitable deduction so long as the charity is a beneficiary under the last will and testament, and the last will and testament explicitly provides that income can be used or must be used to satisfy the charitable distribution. However, because of the perhaps discord between the income recognized by the estate before making the charitable distribution and the deduction going to the charity, there may not be a completely offsetting charitable deduction. So we tend to avoid having the estate be a beneficiary of the IRA in virtually all situations. On the next slide, Alan, we'll talk about a similar situation where a trust is the tool that is used to pass assets to a charity and to a non-charitable beneficiary. Now, this works a little bit better. However, as I mentioned, you want to make sure that the trust disposition to charity is set forth as a fractional devise. Because if it sets forth a dollar amount, the IRA assets would have to be liquidated or deemed to be liquidated upon distribution to the charity, which could create income to the trust, and the deduction from the trust to the charity might not exactly offset that amount. So the best way to do this is to have the retirement plan passed directly to charity. And what we've done typically is provide for a percentage in the beneficiary designation if the custodian lets you do so. And the next slide, Alan, shows that technique where you have, a beneficiary designation saying X percent of the IRA will go to ABC charity and Y percent will go to my family or my sons or my daughters. And that allows the assets to pass to charity without triggering income tax as a result. And it also allows the IRA that goes to the individuals to be subject to the 10-year rule or perhaps the longer lifetime stretch if the beneficiary is what's called an eligible designated beneficiary. These new tools and words that have come out when the Secure Act was passed. So the next slide, Alan, shows the pecuniary devise. As I mentioned, if you do this directly to charity, if you say, I leave $100,000 of my IRA to the charity and the balance to my son, well, that pecuniary amount does not trigger income tax because the charity itself doesn't pay the income tax. It also allows for the IRA to go to the individuals and be subject to the 10-year distribution rule, where all benefits must be paid out no later than generally 10 years after the participant's death, and possibly the eligible designated beneficiary lifetime stretch rule. The problem is where you have a trust or an estate in the middle, as we looked at on an earlier slide, that can create income to the estate or trust, which is a big no-no, which certainly doesn't operate in the most tax-efficient manner. So in a lot of situations, and Alan, we'll go to the next slide here. On a lot of situations, you'll have a client want to effectuate a charitable distribution to charity based upon a dollar amount or a set, benchmark, whatever that may be, a percentage or a dollar amount. And you'll want to have the IRA assets be used to pay to the charity to soak up that income tax that might not otherwise apply if it went directly to the charity, whereas it would apply if it went to a non-charitable beneficiary. So in this instance, what we would typically do is provide either in the beneficiary designation that the IRA goes to the charity to the extent of X dollars. And sometimes the custodians will let you create a formula that relies on the will or the trust, meaning that what goes to the charity has to be taken into account when you view the trust and the will, so that under all circumstances, the charity is limited to receiving $1 million. Some custodians say, yeah, we don't want to have the obligation to look at the will and the trust and make that determination. So you cannot reference the will and the trust when defining how much goes to a particular beneficiary. In that instance, you can use a trust to operate as the particular, as the receptacle to receive the IRA and then pay out the IRA benefits to a charity. In that instance, we want to make sure that the trust provides that the charitable distribution does use income or must use income so as to allow the 642C charitable income tax deduction to apply. And again, you want to be sure to make that distribution before September 30 of the year following the participant's death to avoid that issue. So Alan, this slide here and the next slide go over what I've mentioned in that you don't want to use an estate and a revocable trust as a receptacle to the extent you can avoid it. If you need an offset provision in a revocable trust, then you have to do so, but don't leave it to the estate because the estate is going to trigger the 5-year rule. If you have the estate involved, it could be problematic. And then again, on the next slide, showing why when you use a trust in the middle to allocate between charitable and non-charitable beneficiaries, use a fractional devise, a percentage and not a pecuniary, so that you avoid that Keenan gain or deemed gain on the distribution to the IRA. So Alan, we're going to skip ahead to just a few more slides here before my time is through. The use of a CRUT as a beneficiary. Now on slide 163 here, we mentioned the disclaimer technique where a child could disclaim to a CRUT and then the CRUT would pay out over the course of a life expectancy or over the course of a number of years. Just skipping ahead to slide 166 to show some numbers as we relate to this. So if you have a taxpayer with a $1 million IRA, and if you assume growth of 7% on the IRA inside the IRA and the CRUT, and 6% out of the CRUT, with an AFR rate of 2.0%, if we go to the next slide, if we skip the CRUT and just leave IRA benefits directly to a non-charitable beneficiary, after 20 years, the beneficiary is going to have $2.2 million. After 10 years, the beneficiary, as Alan is circling, will have $1.2 million. And that's a good benchmark against which we'll evaluate the CRUT. But the way this works is that over 10 years, or at the end of the 10-year period, the beneficiary receives a distribution of all assets. They pay tax on the assets. They have a net of about 1.24 million. And they reinvest that amount into an account that grows at 6% per year. Year 20, it's about 2.2 million, 2.22 million roughly. So the next slide shows what if we used a CRUT instead? So the CRUT, as I said, allows for a deferral of that tax. Now, when the payments come out over the 20-year CRUT period in this instance, each payment, which is based on about 11% of the amount of assets in the CRUT, is subject to tax at the highest level. And after the 20-year period, there's about $450,000 remaining in the trust. The balance goes to charity at the end of year 20, which is about this $450,000 amount. On the right side of this chart, you'll see if the beneficiary of the CRUT has taken the annual distributions, reinvested them at 6% per year. After 20 years, they're at about 1.96 million, which is less than what they would have had under the 10-year rule. But the charity gets 450,000. So the charity wins here as well. The loser is the U.S. government because the government doesn't get the large tax bill that would apply at the end of the 10-year period. And now on the last slide here, coming up next, is really just reconciling how this works. So, if we use the 10-year rule, you have after 20 years, the beneficiary is going to get 2.2 million. If you wait and use the CRUT, you're going to have after 20 years about 2 million. So the beneficiary plus the charity is at 2.4 million, which is in excess of what the beneficiary would receive under using the 10-year rule without the CRUT. So the loser here again is the government. This allows a client to effectuate charitable intentions. It allows them to pass wealth to their heirs and their desired beneficiaries in a very tax advantaged manner. So take a look at the CRUT for IRA benefits. It's very helpful. It can provide excellent technique and excellent tax advantages. Alan, do you want to go on to the next topic, or shall I throw in a little more information?
I think we're good, Chris. Now, how do the numbers look if you do a flip NIMCRUT and you don't pay any tax for the first 15 years?
Yeah, if you don't pay any tax for the first few years, you're certainly going to have a lot better tax result, right? You're going to defer that tax that would be paid up front towards the end when you have the flip. Although when the flip happens, you might have a bigger tax bill at that time based upon whatever the unit trust percentage is. I think that the flip NIMCRUT would probably work out a little bit better financially. It's a little bit more difficult to explain to clients. It's a little bit more difficult to implement. Certainly, using a flip NIMCRUT does have income tax advantages. Now with an IRA, I think providing for the stretch over time is attractive for a lot of clients because that's what many of us were used to before the Secure Act became law in 2020.
Okay, very good, Chris. Really appreciate it very much.
Thank you.
Good work. Brandon, are you on?
I'm here.
Okay, Brandon's been reading the tax law, which is many pages. I have it here, but I haven't been reading it. There it is, what came out last night. Enlighten us, what's going on?
Yeah, so is there a way that I could share my screen? Because I got some slides here that goes through that we can send out to the attendees as well.
No.
Brandon, you should be able to share your screen
Okay.
as well.
All right, let me see here. It's telling me that Alan needs to stop sharing his before I can
Right,
share.
Alan, you'll need to unshare.
Unshare. Well, I'm pretty selfish, so that's easy. Okay.
All right, let's see. Let's do that. And let me get the PowerPoint up here. All right, can we see the PowerPoint?
Yep.
Okay, perfect. All right, so we've had a lot of new proposals come out in the past month or so. The original one was released on September 13th. It included a lot of changes to the estate and gift tax law, including reduction of the exemption, including limitations on the use of grant or trust, deemed terminations to apply generation skipping tax. So basically changing a lot of what we would do, and we would have to kind of reinvent the wheel. The good news is October 28th came around, a revised version of this bill called the Build Back Better Act was released, and all of the estate and gift tax changes were gone. Then last night came around, November 3rd, another version was released, and again, no changes to the estate and gift tax law. So for right now, I think that estate and gift tax changes are off the table. Whether they come back on or come back in through negotiations, your guess is as good as mine. But for right now, things are looking good on the estate and gift side. So what is in this new proposal, and what should we be concerned about? What should we be talking to clients about? Well, number one is this new concept of a surtax on high income taxpayers. So if you have modified AGI, which is a new definition that they've added, essentially it's going to be your AGI without reduction for business interest as well as investment interest. So those two things are going to be back out of the AGI calculations. But if your AGI is in excess of 10 million or 5 million if you file separately, then there's going to be a 5% tax on that excess. So if you have $15 million of AGI, then 5 million is going to be subject to this 5% surtax. The bad news for us as estate planners is for trust and estates, if trusts have income that exceeds $200,000, then this 5% tax applies. It gets even worse if the trust goes up to $500,000, then an additional 3% tax applies on that excess. So a total of 8% could apply here in this situation. For example, if the trust had $1 million of retained income, then the $500,000 would be subject to an 8% surtax. $300,000 would be subject to the 5% surtax. So we got to be really concerned about distributions of distributable net income, passing out that income to beneficiaries, that's a conversation you're going to want to have with the client, and maybe you consider putting special provisions in the trust to allow for distributions of capital gains so that they're not stuck inside the trust, because under most state principal and income acts, unless the trust specifically allows for the trustee to use discretion to pass capital gains out to income beneficiaries, they can be stuck in the trust as principal and cause this surtax to apply. The other thing that we need to be aware of is the trust level of income is taken into account after charitable deductions under 642C. So maybe we include charities as a beneficiary of trust and allow for charitable contributions to come out of the trust pursuant to the governing instrument, get a nice charitable deduction for the trust, benefit charity, and then try to minimize the impact of this new surtax. Number 3 on the list, the net investment income tax is going to significantly change for high income earners. That's those with more than 400,000 of AGI, 500,000 if you file joint. This is now going to apply on any income that's derived from the ordinary course of a trade or business. So even if you have an S corporation, you pay a reasonable salary, dividends come out not subject to employment taxes, well, now they're going to be subject to the 3.8% tax if you're over these income thresholds. So we have that conversation with clients now. Maybe S elections aren't something that we want to do. Maybe we want to delay filing S elections until we figure out what's going on with this bill, whether the net investment income tax is going to apply to those types of ordinary operating businesses these days. Bad news for trusts and estates again. If the trust and estate owns a trade or business, it's going to be subject to the 3.8% tax, regardless of its level of income. Now, it's only for undistributed income, so you can still use D&I deductions to pass out the income to beneficiaries, have it taxed at their individual rates. If they're not above these thresholds, then the 3.8% tax would not apply. So again, we have to be extremely concerned with setting down at the end of each year, looking at trust income. What do we need to distribute? What needs to be retained? But again, we don't want the tax tail to wag the dog. So we need to be concerned of creditor protection of trust and the benefits that that's provide to accumulating assets in trust. So even though these surtaxes might apply, the 3.8% tax might apply, you still don't want to just necessarily distribute out all the income automatically from a trust. It just depends on the client situations. But again, it's that annual meeting to have to determine if and when distributions need to be made. Number 4 on the list, cryptocurrencies, subject to constructive and wash sell rules now. So as of that's effective the date of enactment. So there's still some time here if you have a loss position in a cryptocurrency, unlikely given the large gains that have occurred over the past couple of months here. You could sell that, immediately buy back in, recognize the loss, still be in the same place as far as where you are in the currency, but you would be able to recognize the loss. Well, that's not going to work anymore after this bill is signed. There's going to be a 15% minimum tax on corporations that have more than $1 billion in profits for 3 consecutive years. Basically, it's going to apply on financial statement income of a 15% tax. So a new AMT tax for corporations. Section 1202, qualified small business stock. So if you're a qualified small business, which means you meet certain requirements, you're an operating business and you're not one of the prohibited businesses, which are the same list as the Section 199A specified trader businesses, if you're familiar with those. So accounting, legal, consulting, all those are excluded from 1202. But if you meet the requirements, you could exclude up to 100% of the gain on the sale of stock, as long as you've held the stock for more than 5 years. Well, if this passes and your AGI exceeds 400,000, that gain's now going to be limited to just 50% of the exclusion. So you can't exclude the entire gain, only 50%. So just something to be aware of. This also applies to trusts and estates without any type of income threshold. So those that use trust and multiple trusts to maybe stack the exclusion amounts, you might run into some problems there now if this bill does pass, because you're going to be limited to 50%. Something that was added last night that was not in the prior bill that was released a couple of weeks ago. The IRA limitations are back in. So now we have this idea, if we have a balance that exceeds $10 million and we have AGI over $400,000, we cannot make any more contributions to that IRA. And that's cumulative of all of retirement plan account balances. So if you have multiple IRAs that all add up to more than 10 million, no contributions to any of them. Now, this isn't effective until 2029, so we have some time here to worry about this and plan for this. Also, for those large account balances, to the extent that the balance exceeds 10 million, 50% of that excess has to come out as a required minimum distribution. Again, that's not effective until 2029. These numbers are inflation adjusted. So we'll see what ends up with this, whether that effective date stays, whether it comes back in to be effective sooner, or whether it makes it in the final version at all. Stay tuned on that. State and local taxes, the SALT tax limit. Currently, it's at $10,000. You can't deduct more than that on your personal return. Well, they have increased that cap to $72,500 all the way up through 2031. So for 10 years, you can deduct up to $72,500 if this does pass. That's something that was added in last night in the new version. There's still the funding for the IRS, $79 billion allocated to help with enforcement and auditing. So, just be aware of that. There's also a lot of international taxation changes that truth be told, I'm just not familiar with to know what they mean at all. So we'll leave those to other experts. The good news, again, no increase in personal tax rates, no compressing brackets, no reduction of the estate and gift tax exemption amount, no mention at all of grant or trust and whether or not those would be impacted in any way. So we continue to use grant or trust as we always have. No mention of preventing valuation discounts in any way. Some of these things were mentioned in prior bills, not mentioned anywhere in this new version. No increase in the capital gains rates, no proposal to tax unrealized capital gains or tax capital gains on death. Section 199A remains. The thought that appreciated assets when they're gifted into complex trusts might be subject to income tax. That's not included. Limits on annual gifting and use of crummy withdrawal powers and trusts. So you can, contribute up to $15,000 per beneficiary each year to a trust. No limits on that. No changes of the estate tax rates to make them more progressive. No proposals to untie the gifting exemption with the estate tax exemption, as was in the some previous bills. No proposals to assess generation skipping tax via deemed terminations every 50 years. So there's a lot of good news, I think, in this bill, and a lot of things that weren't included, particularly related to estate and gift tax planning. But there is some new income tax things that we need to be concerned with, particularly as they apply to trust and estates, that may change the way we draft some trust and just need to be thought given to and close eye kept on those items, and we'll just see if they make it in the final bill or not, and what comes of those, and figure out what we need to do for our clients. So, Alan, any final thoughts on these changes? We'll try to get these slides out to attendees. There's some more details here, some more planning ideas as well. So we'll have those passed out as well.
We'll know a lot more by 4 p.m. for our talk at 4 on the new tax law.
Yeah.
Well, Brandon, thanks very much for pulling that together, and we appreciate it very much. I guess we'll close this presentation by saying that I started asking each of you to find 3 charitable planning opportunities that you would put into effect somehow in your practice or in your personal life. So I hope that you'll think through some of what we talked about. I know I flew through a lot because part of the game here, part of the goal is to do more for charity and to help clients do more for charity. It helps them financially, it helps their health, it helps their psychological well-being, and it helps the community. So I welcome any questions you might have. You have my email address. Thank you very much for the opportunity to speak. It's an important day for me and very appropriate that I'm speaking for an estate planning council, because that's where I started my career 1 month out of law school. Thank you very much.
No, we so much appreciate you speaking for us, Alan. That was great, very informative, and thank you, Brandon and Chris, for your contributions. We truly appreciate you sharing all of your insight with us. I don't see any questions. So just a reminder, that this was recorded. So if you want to go back and watch it, I know a lot of information here. So go back and watch the different planning techniques and everything. That will be posted on the member section of the website under links. And as I mentioned in the beginning, remember to please complete the survey. It should come up at the conclusion of the meeting, and you'll also be emailed the survey. So, and then of course, CPE certificates will be emailed to you. Now, our next meeting will be December 2nd, and it's actually going to be back in person at the Harbert Center for the first time since March of 2020. So, really looking forward to that. Looking forward to seeing everyone. There will also be a Zoom option. So we're going to, do these meetings, attempt to do these meetings hybrid from now forward. So, of course, if you prefer to attend virtually, you'll have that option. And this will be a 2-hour meeting. So we'll close out the year with Jonathan Blockmacher presenting a tax update for us. So thank you, everyone, for your attendance today. Have a great day.